Hello, everyone. I'm Tanya Rivero. Thank you for joining us. The murder trial for former Minneapolis police officer Derek Chauvin is finishing up its second week of testimony today. We are expecting to hear this afternoon from the medical examiner who performed George Floyd's autopsy last summer. So far, we have heard from forensic pathologist Dr. Lindsay Thomas. She explained how she used video of Floyd's arrest to rule out other causes of death suggested by Chauvin's defense team.
What I observed from all of these videos is this was not a sudden death. Mr. Floyd did not, it's not like the snow shoveling where I told you somebody comes in, collapses and, clutches their chest and falls over. There was nothing sudden about his death.
Do you have an opinion to a reasonable degree of medical certainty if Mr. Floyd would have died that night had he not been subject to the subdual and restraint of the police?
There's no evidence to suggest he would have died that night, except for the interactions with law enforcement.
Vinoo Varghese joins me now for more. He is a criminal defense attorney and former prosecutor. Vinoo, welcome. Great to have you with us. So to a lay person, those comments may mean one thing, but what did you take away from the forensic pathologist's testimony on how this could impact the case?
Well, I think that there are overstatements being made by her, saying that there's no other potential cause of death. She also later testified through cross-examination by Nelson that if she had found George Floyd home in his house dead with the amount of drugs in his system, she would have classified it as an overdose. So it's actually ridiculous for her to say that there was no other possibility of death other than what she witnessed. Now, the question then becomes, and I didn't see Nelson going into this much, is what videos did she watch? Did she watch all of the videos that have been played so far, including the ones put forth by the defense, and also the videos of George Floyd, resisting arrest that before he was brought into the car and then put on the ground? All of that, these are questions that Nelson should have gone into a little bit more and to get to this point. But it appears, look, when you hear this testimony and you're sitting there and you're taking these sound bites, it appears quite damaging to the defense and really undercutting their theory. But he has money. There's been money raised, a certain amount of money, and presumably they have their own experts who are going to say that all of this, that the drug use combined with his inherent medical problems, all of this contributed to his death, and that Chauvin's knee, whether it's in the back or on the shoulder, is not what ultimately killed him.
So we are still expecting to hear from the medical examiner who conducted Floyd's autopsy. What do you want to hear specifically from him, and how does Dr. Thomas's testimony set that up?
Well, it's not just Dr. Thomas. Every forensic person and doctor they've had testify before the medical examiner is there to attack the medical examiner, even though it's the state's own witness. They were not happy with the report because it started off by saying that he died of cardiopulmonary arrest, complicated by law enforcement. Is very weird phrasing, complicated by law enforcement techniques. But what you're going to hear from him is saying that, yeah, it was the law enforcement restraint that caused death, that caused the heart attack. What they're saying, what these people are saying, is that he died because the law enforcement caused the heart attack. And he also noted in his report about the drugs in the system. So you may get a concession from him, from the defense, at least through the defense attorney, that drugs played a part in his death. And that's different from what all these other people are saying. All these people that have come in and being paid by the state to come in to basically neutralize their own medical examiner's report.
All right, so if you are working for the defense here, because clearly you feel like the defense needs to make some points, or hit some points, what are you looking to focus on when it is your chance to present your witnesses?
Presumably they have experts that are going to say the opposite of what the state's experts have, right? So let's put it this way: they better. And these experts need to say that drugs played. Look, they have a theory that they've been using since opening statement, They've used this theory that drugs are what caused, or the drug overdose, and all of this caused, and George Floyd's underlying health conditions, a combination of all this. They need experts to back that up. If without those experts, then the defense will fall flat, because you're in a situation where you have this video that is obviously, when you look at it, the initial video looks horrifying. What Nelson has done, and has been watching this trial, is show other angles, and he's been picking away at the prosecution case. He doesn't need, the Tom Cruise, you can't handle Jack Nicholson, you can't handle the truth moment. He doesn't need that. All he has to do is pick holes and then tie it all together in summation to make the argument that there's reasonable doubt. If there's reasonable doubt, all you need is one juror to hold out, and then you have a mistrial, and then Chauvin lives to fight another day. And the second time around benefits the defense, because now you've seen the prosecution case. It isn't going to change that much.
So we've also learned, Vinoo, that before proceedings began today, the judge briefly questioned one of the jurors about having potentially seen any outside information going on in the trial. So what do we know about this, and how significant is it?
Well, it is significant, and you've got to assume, and as a defense lawyer, I assume that at least some of the jurors, not all of them, are probably not being completely honest. We live in a day and age that's been like this way for years of instant media, social media, and everybody's going to be looking at their phone. It's hard to avoid that, right? And you don't sequester jurors anymore and put them in a room without TV. You can't do that. So therefore, there's going to be some contact. The question is, based on the information the judge received today, that this woman got a text message from her mother-in-law, and it wasn't much more than that, or she saw something on the television but didn't watch it, there isn't enough to strike her. But the question is, how did this get to the judge, right? And it is disturbing to know that somebody brought this up. It didn't appear that the woman brought it up to her attention, but somebody found out and was able to tell the judge about this, but there wasn't enough to strike her at this point.
Mm-hmm. Right. All right. So much to consider. Vinoo, Varghese, thank you so much for joining us. We appreciate you sharing your legal expertise with us.